and also in 2 cases on that same date. And what that means, sir, is that if you go to trial in that robbery case and the murder case and the robbery, I do want to also make sure you understand that after today, I will not accept this plea agreement. This plea agreement is already extremely low for the criminal history. Even though some of it's very old, it is significant. All right. So, Ms. Williams, in cause number 26, DCCR 0218, you're charged with a state felony offense of theft of property with previous convictions. That's from November 25th of 2025. Your indictment alleges you were previously convicted of theft May 12th of 92, and then 3 cases, January 11th of 1994, again, October 9th of 2006, April 13th of 2011, May 2nd of 2012, October 6th of 2014. And then your indictment further alleges that you were convicted of forgery, a 3rd-degree felony, August 4th of 1995, 2 cases on that day of forgery, and then another of securing execution of a document by deception. And then after those were final, you were convicted of possession of a controlled substance, a 3rd-degree felony, December 18th of 2017. Well, what that means is that if you go to trial and you're found guilty and all of those prior, or at least some of those prior convictions are true, you would be facing punishment as a 2nd-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes.
And I have here, and that's in both of your cases. The second case is 25 DCCR 1430. It charges theft of property with previous convictions, and that one's from August 9th of 2025. Again, with those same prior convictions listed and the same possible punishment range. You understand that as well.
Yes.
And then I have a plea bargain rejection that you've signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to proceed on count 1 only for an 18-month state jail term in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand that before we go to trial, what your options are and what the possible consequences are if you go to trial. And do you understand all of that? And you want to reject that offer and have your case set for trial. You have both cases set for trial. Okay. I do want to also make sure you understand that after today, I will not accept this plea agreement. This plea agreement is already extremely low for the criminal history. Even though some of it's very old, it is significant. And so and it's fine if you're not guilty of both of these offenses, then that's what a jury's for. So I'm not trying to talk you anything. I'm just trying to tell you that I'm not going to accept this plea agreement after today. Do you understand? Okay.
Just for the court to where it is that one reason it's been reset is there's supposedly people are going to sign a non-prosecution affidavit. Well, the affidavit that she's not the one that did it, and she has got it signed, but it's not notarized. And I told they need to go to the DA's office. So that's the only.
And y'all haven't had anybody come to do that?
I think so. This is not my case. This is.
I cannot hear you.
This is not my case for the small fingers.
Okay.
But she has not. No, nobody has been there. Yeah.
Hold on.
Okay. Okay.
Ms. Williams, if I test you this morning, will you have anything in your system?
No.
Have a seat in the jury box. We're going to double test that before I reset it for trial.
I'm going to check in.
Ms. Williams, so did you take the test? The drug test?
I think this looks like 21 years since was John.
What do you take? 24 medicines?
I have neuropathy. I have verticals. I have 3 prisoners on the side of my spine. I take hydrocodone. I take for anxiety. My blood pressure was 230 over 134 3 days ago.
How did you get here today?
My ex-husband brought me.
So are you driving?
No, ma'am.
Do you ever drive?
No, ma'am.
So-
The doctor don't want me to drive. He took my license and put me back at Class B because I could have an aneurysm like I do.
All right. So here's the thing, Ms. Williams. I'm going to order also as a condition of your bonds in each of your cases, which is 260218 and 251430, that a condition of your bond, you are not allowed to drive ever any vehicle. Do you understand?
Yes, ma'am.
All right. And so
I can bring in letters.
that's okay. And so we'll move these then. You want to, I've already done the rejection.
Rejection.
There. Oh, there it is. All right. So Ms. Williams, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker in your cases. Is that okay with you?
Yes, ma'am.
All right, then I'm going to release you, Mr. Parker. Ms. Williams, if you'll just, you're ready, step in front of the clerk. She will give you the information now on who that attorney is and when you need to contact them.
Thank you.
Yes, ma'am.
Thank you, Judge.
Thank you. All right, sir, are you Marvin Lee Watts
Johnny.
Jr.? And Mr. Parker, will your client waive the formal reading of the indictment in each case?
That's Shannon.
Mr. Watson, cause number 25, DCCR 1918. You're charged with the first degree felony offense of aggravated robbery from October 2nd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in clause number 26, DCCR 0946, you're also charged with a first degree felony offense of aggravated robbery. This is from September 12th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with. In each of those cases, I have here on the tablets documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand that? And do you understand if I follow the agreements that you've made with the district attorney's office that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of your cases is for a cap of 17 years in prison, which means you're leaving your punishment up to me. I can give you 17 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have every right to have a jury come in and decide 2 things. First, to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that. And is that what you want to do? So you have, what you've agreed to is a cap of 17 years, which means a cap. All that means is that you're leaving your punishment up to me. And you could, if you wanted, have a jury decide instead of me. But if we go forward this way with the papers that you've signed that says that you're waiving a jury and that you want me to sentence you within that range of punishment, which would be between 5 years up to 17 years, there's the possibility of probation. It'll all, again, depend on what information I get when we come back for sentencing. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Watts is not competent?
Second.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases. for when we come back for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Parker. He'll present it to me on your behalf. Okay.
Yes.
Right. You can go back with the
Thank
baby.
you, Judge. Thanks for getting me in.
Yes, sir.
Thank you, Your Honor.
Good morning.
Franklin. On the way up, he understands what's going on. Judge, I have my assistant and help to translate. We're going to reject the offer today.
Okay. You need to do that in writing. There's a plea bargain rejection on the tablet, and then I'll call it up. And by the time she can be up here and help me go through that and make sure he understands all of that.
Yes,
Okay.
Your Honor.
I'll hold it.
Go ahead and do it.
All right.
I'm sorry we had a little emergency in the parking lot with a different county and this
Okay. That's okay. No problem. Yeah. No
We'll
problem.
get it done, Judge.
Sure.
Thank you.
And they can, if you need some help, I'm sure one of the attorneys can.
I probably will.
Okay.
She's my
Good morning, Ms. Cantu. Good morning. Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English? Yes. Thank you, ma'am. And sir, are you Guadalupe Reyes? Yes. And Mr. Reyes, in cause number 25, DCCR 1422, you're charged with the first degree felony offense of aggravated robbery from May 25th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it. Before you sign this, did you go over it with Mr. Wasserstein?
Yes.
Do you fully understand it?
Yes.
It shows that if you wanted to enter a plea of guilty, that the state is offering a cap of 15 years in prison, which means you would leave your punishment up to me, but I couldn't give you more than 15 years. I could give you 15 or less. It would depend on the evidence that was shown to me at a sentencing hearing later. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
All right, then we will move your case to the trial docket, and Mr. Wasserstein will begin preparation. Stay in touch with him. He'll let you know when you need to be back and ready for trial. Right? Thank
thank
you.
you for the opportunity.
Thank you. You're free to go. Good morning. Are you Leroy Harris Jr.? And this is cause number 24, DCCR 0404. Mr. Harris is charged with the first degree felony offense of murder from December 3rd of 2023. And Mr. Harris, that indictment alleges that you were previously convicted of robbery May 9th of 2012. And also in 2 cases on that same date. And what that means, sir, is that if you go to trial in that robbery case and the murder case, and the robbery case is true, that conviction, then you would be considered enhanced punishment, which means your punishment would be, if you're found guilty, a minimum of 15 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet, and I'm making that notation that I've admonished them to the enhanced. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 40-year term in the murder case with a dismiss in the pending felony. What pending felony is there?
Drug case in there somewhere.
Well, that's the MTRP. So really wouldn't be a dismissal of it. It's just the MTRP on a state jail felony. Well, so I'm going to mark through that also. Whatever happened, if you took that 40 years on the murder, then something would be figured out with the state jail felony motion to revoke that would run concurrently or at the same time. Correct?
Yes. And Judge, I apologize. I think Mr. Burbank and we were trying to talk over a bunch of people. That should be 30.
30,
Yes.
not 40.
Correct.
So is it okay? So Mr. Harris,
I don't think it makes a difference, but just with paperwork.
so the offer is for 30 years in the institutional division of the Texas Department of Corrections. Do you understand what your options are if you wanted to enter a plea of guilty? And do you want to reject that offer and have your case set for trial? All right, we'll get it set on the trial docket, and Mr. Burbank will begin preparation for trial.
Thank you, Anna.
Thank you.
Is that,
Yes.
And Judge, just may I, for the record,
Yeah, hold on just a second.
why this case is the age it is obviously the court is aware. Mr. Harris, having been in Harris County, there has subsequently been a conviction over there for murder. I believe it was a lesser included of a capital. He received 12 years on that. It will be my intention to get from Ms. Rogers, the DA over there, what I can, probably a PSI, and get that to Mr. Burbank. But it just adds a little bit of supplemental discovery just at this juncture. So we'll keep the court informed if that changes our negotiation. I'm just not quite at this point in a position to make any other offer. If I am, I'll come to the court first.
Okay, thank you. All right, you can go back with the bailiff. And then you've got Asa Jones, Mr. Burbank.